Hi, folks. We're going to continue talking about the availability of judicial review. So, just a little bit of a reminder, right? Section 701A1 and Section 01A2 indicate two different ways that judicial review is precluded, and therefore the rest of Section 7 of the APA will not apply. Section 701A1 applies when the statute explicitly in its language precludes judicial review. Now, what we've seen so far is that courts don't like this. Right? Courts are very jealous of their power, and even when a statute actually includes a specific bar on judicial review, courts repeatedly have said, obviously, that doesn't include constitutional questions. So courts read statutory language precluding judicial review very narrowly. They will at most allow Congress to bar judicial review of statutory questions, but not constitutional questions. Then we get to Section 01A2, right? When decision is committed to agency discretion by law. And right, that is a potentially amorphous provision and could be extremely broad. It could be broad enough to sort of eat the general rule of judicial review. But again, courts have interpreted this very specifically. So what we saw in Overton Park, which is the sort of definitive statement to date of what does it mean to say that a decision is committed to agency discretion by law. And in Overton Park, the court said that that applies only when the law provides no standards by which a court could evaluate the agency exercise of discretion. And under those circumstances, a decision is committed to agency discretion by law because there's no way for a court to evaluate the agency's discretion. Now, that might raise a different problem that we'll talk about in the non-delegation context, but for now, for our purposes of understanding Section 701, when a court does not have standards by which to evaluate an agency exercise of discretion, there's no way to apply the Section 706 abuse of discretion judicial review standard, and therefore the court said that the decision has to be committed to agency discretion by law. Now, notice what this does, what Section 701A1 and Section 701A2 do not address, and that is something that is very common in federal statutes, which is channeling of judicial review. For example, requiring that somebody exhaust their administrative remedies before bringing a challenge in federal court, and specifying which court, either federal district court where somebody lives, federal appellate court where somebody lives, or the DC Circuit, right? That kind of channeling as to who will decide a judicial challenge to an agency action is perfectly fine in general, right? But as we've seen recently, and as the Supreme Court may be deciding in the Jareski case, we'll have to see. Jarchese, I always say his name wrong. But in the Supreme Court may be addressing this question very soon, because when somebody is trying to raise a constitutional objection to agency action, right? Courts recently have said there is no exhaustion remedy because the harm is when the challenge is to the agency decision itself, the harm would be going through the agency process that reaches the decision. And under that circumstance, the court said that channeling, which is ordinarily quite fine in terms of federal statute limiting judicial review, that channeling is not okay in the context of a constitutional objection to the agency power to do whatever it is doing in its first place. Okay, so let's just remember what we're talking about in terms of the agency action. So Section 702 tells us that any person suffering legal wrong because of agency action can seek judicial review. So what does that mean? What does person mean under the APA? Right? We've seen that person is defined very broadly to include an individual, partnership, corporation, etc. Right? And basically anyone other than an agency. The APA is not, remember, a grant of federal court jurisdiction, but it authorizes judicial review when jurisdiction otherwise exists under another statute. Right? So this phrase within the meaning of a relevant statute becomes critical. And so let's look at what does agency action mean, right? We saw person is defined under the APA, but so is agency action. And since Section 702 gives a right of review to any person suffering a legal wrong because of agency action within the meaning of a relevant statute, it sort of matters what agency action means. And just a reminder of the definition of agency action, right? Section 551, subsection 13, defines agency action to include not only the whole or part of a rule or order or etc., but also an agency's failure to act. Now, what does that mean? Can it really be that anytime an agency decides not to act, there's a cause of action under Section 702? I mean, sort of saying that it answers it, right? That can't be what the rule means. So to answer this question, courts have had to interpret the meaning of agency action within the meaning of a relevant statute. And particularly, what does it mean to say that an agency action includes a failure to act? So Heckler v. Chaney is the definitive statement on this front with regard at least to enforcement. Right? Here the court interpreted a cause of action under Section 702 with respect to Section 01A2, exception for things that are committed to agency discretion by statute. Now, if the APA bars judicial scrutiny of agency decisions committed to agency discretion, it's probably not surprising that courts often find that challenges to an agency refusal to act are non-reviewable on this ground, even though refusal to act is included in the definition of agency action. Because agencies invariably confront more cases than they can handle, more problems than they can solve, and more issues than they can explore given both budgetary and time constraints. Now, it's not obvious by what criteria a court might determine that agency inaction, which often really is an agency preference for a different action, exceeds discretion. So that brings us back to that point from Overton Park of how's a court supposed to evaluate whether an agency has abused its discretion or not, right? When an agency decides not to take a discretionary action, how should a court evaluate that? And in Heckler v. Chaney, the court treated as presumptively non-reviewable an agency's refusal to exercise enforcement authority in an entire category of cases. Right? Specifically, the court refused to review an FDA decision to not use its enforcement authority against the way that multiple states were using certain prescription drugs in the context of executing people who had been convicted of capital offenses. even though those drugs had not been approved as safe and effective for this purpose. The court concluded that the range of permissible factors generally relevant to non-enforcement decisions means that unless Congress established some kind of specific guidelines for the exercise of discretion, enforcement decisions are ordinarily going to be committed to agency discretion within the meaning of Section 701A2. Now, in many ways, Heckler v. Chaney was an easy case, because if you phrase the question about judicial review as, did Congress intend to regulate criminal sanctioning practices of states through the Food, Drug, and Cosmetics Act? Right? It's pretty clear that the answer to that is no. So I don't think that was a very difficult decision for the court to reach. And in general, what we see is that agency refusals to exercise enforcement authority are viewed as uniquely within the purview of the agency and therefore not subject to judicial review. But does that same rationale apply when an agency has refused to engage in rulemaking? And the answer to that is typically no. In most instances, agency refusals to make rules are likely to be based on the same kind of priority setting and resource allocation that influence decisions in enforcement actions. But unlike the enforcement context, the court has found a presumption in favor of reviewing agency refusals to engage in rulemaking. And we're going to look at Mass versus EPA, which is one of the decade's more dramatic administrative cases on several fronts, where the court held that agency decisions not to make rules fall under the presumption of reviewability in the APA rather than the Heckler v. Chaney presumption that decisions not to act in the enforcement context are committed to agency discretion by law. So first, a little context and the sequence of events. In 1999, EPA received a petition to regulate greenhouse gas emissions from motor vehicles under Section 202 of the Clean Air Act. The petition came from a number of states, including Massachusetts and New York, and an array of NGOs. Now, EPA sat on this petition for more than a year before finally requesting public comments about whether or not it should regulate in this context. And EPA received more than 50,000 comments during the comment period. EPA also asked the Natural Research Council for an assessment of the science, and most specifically the scientific uncertainties about climate change. Now, before we talk about what EPA did substantively in this case that was right on appeal, let's talk about the process. So not only does the APA define agency action to include a failure to act, but Section 553E, the section that governs informal rulemaking, explicitly requires that agencies shall give interested persons an opportunity to petition for rulemaking. Right? So already this claim is on a different footing from Heckler v. Chaney, because each agency shall give an interested person the right to petition for the issuance, amendment, or repeal of the rule. So here there's statutory process that Massachusetts and the other plaintiffs invoked, right? They invoked their right under Section 553 to petition for the issuance of a rule. And the APA also requires a response to a petition. So Section 555E requires that prompt notice shall be given, again, shall be, not optional, prompt notice shall be given of the denial in whole or in part of a petition made in connection with any agency, right, at the request of an interested person. And this notice shall be accompanied by a brief statement of the ground of denial. So to the extent that the objection of the court to exercising discretion in Heckler v. Chaney was based on the fact that agency action is more easily reviewable than agency inaction because agency action gives a locus and structure for inquiry. Right, the affirmative agency action provides a natural focus for review, as the court said. Right, this objection does not apply to an agency refusal to engage in rulemaking in response to a petition under Section 553E because Section 555E requires a written statement. There's therefore an agency action, even though it's a refusal to act, that the court can focus on and can evaluate. Right? But it's important to point out, to the extent that Heckler v. Chaney was a recognition that agencies juggle multiple priorities and that courts should defer to the way the agencies balance those priorities, as opposed to just saying, how we have no standard by which to measure this exercise of discretion, right? When it's about juggling priorities, rulemaking probably doesn't seem that much different because those same questions of priorities and judgment are implicated. Okay, so let's go back to the substance of Mass v. EPA. Right, so we saw, right, there's this lengthy process of the petition is filed, the agency sort of kicks around what they should do, and then in 2003, right, 4 years after Massachusetts and the other plaintiff filed their petition, EPA issues an order denying the rulemaking petition. So EPA has refused to regulate greenhouse gas emissions from vehicles under Section 202 of the Clean Air Act. Now you can see on this slide that EPA had two basic reasons. One, EPA says we don't have authority under the Clean Air Act to regulate climate change. Right? So EPA is saying we don't have the authority under the language of the statute to engage in the requested rulemaking, therefore we have to deny the petition. Second reason is, even if we do have the authority under the statute to engage in the rulemaking requested in the petition, we are exercising our discretion not to engage in rulemaking, and we have that discretion under the statute. So EPA is saying we have used our judgment to decide that rulemaking is not appropriate. So in order to assess these two reasons for denying the rulemaking petition, we have to look at what does the statute say. Right, so let's look at the Clean Air Act section in question. Clean Air Act section 202A says, in relevant part, the administrator shall by regulation, right, shall, not optional, mandatory, the administrator shall by regulation proscribe standards applicable to the emission of any air pollutant from vehicles, which in his judgment cause or contribute to air pollution which may reasonably be anticipated to endanger public health or welfare. So this is the language that the petitioners were seeking to invoke, and that EPA says, one, affirmatively do not give the agency the authority to regulate greenhouse gases, and two, if it does give the agency that authority, it also gives the agency the discretion to decide not to do it. So the question is, can the plaintiffs challenge EPA's decision not to engage in rulemaking under this section of the statute? So there are a bunch of issues here, right? Issue number one. Is this decision simply Heckler v. Chaney second round? Right? The court has to consider, as a general matter, whether the refusal to promulgate a rule is presumptively unreviewable, like the refusal to engage in enforcement. And the court here says no. Because of the APA structure, these decisions are presumptively reviewable. Therefore, the court says they have to review to assess whether the agency action, the refusal to engage in the requested rulemaking, is arbitrary and capricious or an abuse of discretion or not otherwise in accordance with law. So in rejecting the claim that the decision not to issue a rule in response to a petition is committed to agency discretion by law, right? In rejecting that, the court instead says that courts must review a decision not to issue a rule in response to a petition for abuse of discretion and is otherwise specified in Section 706 of the APA. So let's look at EPA's reasons, right? Reason number one that EPA offers is that carbon dioxide is not a pollutant under Section 202A, and therefore Section 202A doesn't give the agency the authority to regulate. So it turns out that, all right, let's just remember again, right? The EPA, this is what the Clean Air Act says, right? The statute says that the administrator shall, by regulation, prescribe standards for air pollutants, right? That's the part that we need to focus on right now. So in order to respond to EPA's reason number one, right, that greenhouse gases aren't air pollutants, the court has to decide whether this language prevents EPA from regulating greenhouse gases. Now, it turns out that Congress defined the term air pollutant. So when Section 202 says the administrator shall regulate air pollutants, we have to read that in context with Section 302, which defines air pollutants. And this is an extremely broad definition, right? The term air pollutant means any physical or chemical substance or matter which is emitted into or otherwise enters the ambient air. The court says that this statutory text forecloses EPA's reading of Section 202 because this is a sweeping definition that includes any airborne compounds, and clearly carbon dioxide, methane, and nitrous oxides, among other things, qualify. Right, so the court says this statute is unambiguous. Now, this should be ringing sort of Chevron step one bells in your head. The statute is unambiguous, so the agency doesn't have the discretion to interpret it. What the court here says is that EPA cannot interpret air pollutants to mean something other than what Congress has defined air pollutants to. And Congress has defined air pollutants to mean any physical or chemical substance that is emitted into or otherwise enters the ambient air. Now, in attempting to justify its claim that Section 202 does not include greenhouse gases, EPA pointed to Congress's failed attempts to regulate greenhouse gases after Section 202 and 302 were added to the Clean Air Act in 1972 and amended in 1978, and statements of individual legislators. The court says you can't do that, right? Post-enactment congressional action and statements can't justify the claim that Congress did not give the agency the authority to regulate greenhouse gas emissions when the plain language of the statute does in fact give them that authority. And I just want to point out that in making this argument, Congress invoked sort of the prototype of the major questions doctrine from Brown and Williamson, arguing that responding to climate change is an elephant, and that Congress couldn't have intended to hide that elephant of responding to climate change in this mouse hole of regulating pollutants from greenhouse gas emissions. They lose on that point. So this brings us to EPA's reason number two, because EPA says, first, we don't have the authority to regulate greenhouse gases under Section 202A. And then reason number two is, even if we do have the authority to regulate greenhouse gases under Section 202, we are exercising our discretion not to, because it is unwise to regulate greenhouse gas emissions at this time. Right, EPA is claiming that the statute gives EPA broad discretion to decide whether and how to exercise authority under Section 202. And here EPA has decided not to exercise that authority for good and valid reasons. Basically, we're just like Heckler versus Chaney. Don't interfere with our priority setting and our judgment. Now, the court says, EPA, you're right. You do have discretion under Section 202A, but not the discretion that you're claiming. Because Section 202A does give EPA discretion to not regulate an air pollutant, but only when EPA forms a judgment that emission of that pollutant will not cause or contribute to air pollution which may reasonably be anticipated to public health or welfare. So the court says EPA's discretion here is narrow, and that EPA must assess, in response to the petition, before they can deny the petition, they have to assess whether the pollutant at question, carbon dioxide and greenhouse gas emissions, may cause or contribute to air pollution that can be reasonably anticipated to endanger public health or welfare. And instead of forming that statutory judgment, the court says EPA instead decided that this regulation should not be issued based on other grounds. Court says that EPA offered a reason divorced from the statutory text. Right? EPA is claiming that, in fact, issuing this regulation would constrain the priorities of the president. And in making that claim, EPA is trying to make a Webster argument. Remember the case where the CIA fired a clerk because of his sexual orientation, or a Laird argument, right, the shipping troops to Vietnam case, because the EPA is trying to make an argument that this decision is attached to a core presidential function, right, the function of foreign relations. Because their rationale is that regulating greenhouse gas emissions from vehicles will tie the president's hand in negotiating with other states for a more global response to climate change. The court rejects that argument. The court says that the agency has an obligation to make a decision based on the statutory terms. So that means that EPA has to engage in what we call an endangerment inquiry and make a decision about whether it thinks that carbon dioxide emissions cause or contribute to air pollution that may be reasonably anticipated to endanger public health or welfare. If the answer to that is yes, then EPA doesn't have discretion to refuse to regulate. The Clean Air Act section requires that EPA regulate any emissions of air pollutants that endanger. But if the answer to that question is no, then EPA doesn't have the authority to regulate under this section. So EPA has to respond to the petition because the Administrative Procedures Act says that EPA has to respond to the petition. And once it does so, its reasons must conform to its authority under the Clean Air Act. Now, in dissent, Justice Scalia writes that nothing in Section 202 requires the administrator to make a judgment. He would let the agency exercise discretion not to engage in making an endangerment finding if the agency decided that it would be better not to regulate on this time. So in doing so, he basically reads the endangerment language not as a limit on EPA's discretion not to regulate. Instead, he sort of reads it out of the statute. He says that the statute doesn't list reasons for which the administrator may defer making a judgment and would use that statutory silence as a reason for the agency to have discretion to not engage in rulemaking. So my questions for you, right? You might want to pause here because these are the questions I want you to answer. Question number one, once there was a petition to regulate, what is the majority's reasoning about what EPA's options are? And how does that fit with the cases that we've talked about so far? Question number two, where is Justice Scalia's departure point from the majority decision? And question number three, which do you find more persuasive and why? And question number four, what does this decision tell us about separation of powers. So you might want to pause here and take as long as you need to answer these questions. Remember, this is not a writing assignment. I don't want an essay. You can use bullet points if you want, right? This should not take you a tremendous amount of time. I just want to know what your thoughts are about this case. And then when you're done, we'll move on to the last slide, which is just a series of reminders. Right? First of all, I want to point out that many statutes, including our old friend the Clean Air Act Hays provision that we've talked about so many times, contain action forcing provisions requiring agencies to regulate rather than giving them any discretion. Right? These provisions, what we call action forcing provisions, direct an agency to issue regulations rather than giving the agency discretion about whether to issue them or not. And you can see that Section 202 is sort of right in between there. It doesn't just say the administrator shall regulate air pollutants, which is defined extremely broadly, right? It says the administrator shall regulate air pollutants when. And then after the when is the agency has to make a judgment call. So you can see that's a little bit different from the Hays provision or from many other statutory provisions that simply direct an agency to promulgate regulations to achieve a goal identified in a statute. And in creating action forcing provisions, Congress can also give the agency a deadline. Right? We saw in the Hays provision that Congress said not only must the agency promulgate regulations, but must do so by a statutory deadline. Now, the thing about statutory deadlines is they are frequently unrealistic. Agencies frequently blow them because it takes a while to engage in regulation, particularly if it's a complicated subject and particularly if the agency is starting from scratch. An agency can be sued for violating a congressional deadline because congressional deadlines are not optional. So we see cases like that all the time. And usually what a court does is set a schedule by which the agency must regulate, or there's some consequence. Sometimes the consequence is that the court will write the regulation. Sometimes the consequence is that the agency is held in contempt. It can be a wide array. Now, one more thing before we close, and that is I just want to point out the Norton versus Southern Utah Wilderness Alliance case, which was decided before Mass v. EPA. But that was a decision that was written by Justice Scalia, and it was an attempt by an environmental organization to force the Department of Interior to take steps that they say were required under statute. Right? So it was positioned similarly in many ways to Mass v. EPA and was very different from Heckler v. Chaney, where the petitioners were trying to get the agency to do something that was a discretionary judgment call. So in Norton versus Southern Utah Wilderness Alliance, the petitioners were saying that the Department of Interior has a non-discretionary duty, a mandatory duty to take steps to protect areas that were designated as potential wilderness areas and not allow any degradation while the process of designating areas as a wilderness or not occurred. And how the court handled that, how Justice Scalia handled that, is really what he would have done if he'd been in the majority in Mass v. EPA. Interpreted the statutory language not to create mandatory non-discretionary duties, but instead to give the agency discretion to decide. So that is a tactic that courts use a lot, even when the language on its face would seem to be mandatory. Courts are able, when they want to find some discretion in whether or not to engage in the duties. So, in the end, what have we got? I don't really have an answer for you. We'll see what the court does with the cases it's deciding this term. But I hope this helps you have a better sense of how some of the pieces fit together in terms of administrative law.